Hello, I'm Kenneth Marcus, the Assistant Secretary for Civil Rights in the U.S. Department of Education's Office for Civil Rights. The mission of the Office for Civil Rights, or OCR, is to ensure equal access to education and to promote educational excellence through vigorous enforcement of civil rights. OCR's jurisdiction includes Title IX of the Education Amendments of 1972. That law prohibits sex discrimination by educational institutions that receive federal funds, which includes most colleges, universities, and public elementary and secondary schools. Title IX requires schools to respond appropriately when they learn of sexual harassment in their educational programs or activities. This includes harassment between students, or between an employee and a student, or even between an employee and another employee. The Department's recently released Title IX rule is designed to create a consistent, predictable, and reliable means of securing non-discrimination in schools, while also providing robust new protections for all those involved in cases of sexual harassment under Title IX. In this webinar, my colleagues and I will explain how the many new protections in the Title IX rule safeguard the rights of all individuals to be treated fairly in sexual harassment cases. The Title IX rule protects rights for all parties, those who may be the survivors of sexual harassment, also known as complainants, and those accused of it or respondents. The Title IX rule was announced on May 6, 2020, and will be effective on August 14, 2020. In a prior webinar, entitled New Title IX Protections Against Sexual Assault, we described the new rights and protections that the Title IX rule offers to complainants, even when they choose not to file a formal complaint. The Title IX rule also creates a new framework governing how schools must respond to formal complaints. As we will explain, the new regulations are designed to ensure that both parties, complainants and respondents, are treated fairly in sexual harassment cases by guaranteeing them a consistent, predictable, and reliable grievance process. First, the new rule entitles all parties to a fair and predictable process. Once a formal complaint is filed, a school has a duty to follow the specific aspects of the grievance process that are set forth in the Title IX rule. Those processes cover the written policies that a school must have, the process of investigating the formal complaint, and the process of having either a hearing or other grievance proceeding in order to determine responsibility, remedies, and disciplinary sanctions. Additionally, the grievance process covers the party's right to an appeal and, if the school so chooses, the option to have an informal resolution facilitated by a trained individual. Before addressing these items, we want to reiterate that a school's response to a formal complaint cannot itself discriminate on the basis of sex. That means that a school can't have a policy of always believing the allegations or denials of one party based on their sex. Additionally, any provisions, rules, or practices that a school adopts beyond the required grievance processes in the Title IX rule must apply equally to both parties. The Title IX rule lays out specific procedural rights and protections for both parties to a formal complaint to ensure both sides a fair grievance process. A school must adopt and publish these grievance procedures and distribute them to individuals in the school community. Key among these protections is the right to have the grievance process function equitably in order to ensure that complainants receive the remedies needed to restore their equal access to the school's education program or activity, and that respondents are not subject to disciplinary sanctions before the conclusion of the grievance process. As a fundamental part of that process, a school owes a duty to ensure that all relevant evidence is evaluated objectively, whether it goes to prove or disprove responsibility for sexual harassment. And the new rule also guarantees that all school personnel handling the process, whether the Title IX coordinator, or investigators and decision makers, or those facilitating informal resolutions, must be free from conflicts of interest and bias, and be trained to serve impartially without regard to the sex of the individuals involved in a formal complaint or a party's status as a complainant or a respondent. All training materials must promote impartial adjudication of complaints. At the outset of the grievance process, one key protection is that a respondent is presumed to be not responsible for the alleged conduct, although respondents may be found responsible and disciplined at the conclusion of the grievance process. The new Title IX rule also provides that the grievance process must end within a reasonably prompt time frame. While delays are allowed for good cause, these delays must be temporary, and a school cannot announce, for instance, a blanket policy that it will not investigate a Title IX complaint until a law enforcement investigation is concluded. The parties are also granted significant rights to critical information about how schools handle complaints. That includes the right to be informed of the range of remedies and disciplinary sanctions the school may impose, as well as the standard of evidence that the school will apply to a formal complaint of sexual harassment under Title IX, whether the preponderance of the evidence standard or clear and convincing evidence standard. Under the new rule, students will also have the right to be informed about their school's appeal procedures and the supportive measures available to both parties. Additionally, the grievance process must respect all legally recognized privileges. A school cannot access or use any information covered by a privilege unless the person holding the privilege waives the privilege. This includes the attorney-client privilege, a patient-physician privilege, or any other privilege recognized by law.
In addition to guaranteeing a fair and equitable grievance process, the new Title IX rule also provides the parties a range of new protections while that process plays out. Once a formal complaint is filed, the parties must be provided with written notice of the formal complaint, which also must include notice of the grievance processes that we just discussed. The notice also must include specific details about the alleged incident of sexual harassment, like where it happened and when. The school has an ongoing duty to notify the parties of additional allegations of sexual harassment that arise during the investigation and which may be the subject of the investigation. The notice must also include a statement that parties have the right to an advisor of their choice who may be an attorney. It must also include any provision of the school's code of conduct that prohibits making knowingly false statements. The Title IX rule requires that the school, and not the parties, has the burden to gather evidence sufficient to reach a determination regarding responsibility regarding allegations made in the complaint. But that doesn't mean that the parties can't gather and present evidence of their own. Just the opposite. Under the new regulations, schools must not prevent the parties from discussing the allegations or from gathering evidence. And the new regulations require schools to give both parties an equal opportunity to present the relevant evidence that they do gather and to offer any other fact or expert witness that may offer relevant evidence, no matter which side or whose version of events that evidence or witness supports. The Title IX rule also guarantees both parties the right to advance notice in writing whenever they are invited or expected to participate in an interview, meeting, or hearing. Additionally, the Title IX rule makes clear that schools must give complainants and respondents an equal opportunity to choose their own advisors to help them through these stages of the process and to have their advisor present with them. Schools can limit how much an advisor participates in meetings and interviews prior to any hearing, but they have to do so on equal basis for both complainants and respondents. And both sides must also be given an equal opportunity to review and respond to the evidence gathered during the investigation. That entails that schools have to provide all relevant evidence to the parties and give them 10 days to review and respond to the evidence before the school can circulate an investigative report. Then the parties have 10 additional days after the issuance of the investigative report before the hearing or other grievance proceeding occurs. Parties even have the right, if they choose, to provide a written response to the investigative report prior to the hearing or other grievance proceeding where responsibility will be determined.
So far, we've looked at the ways the new Title IX regulations safeguard students' right to a fair and equitable investigation in cases of sexual harassment. Now, let's discuss how a decision maker determines whether a respondent is responsible for sexual harassment and how remedies and disciplinary sanctions may be determined. The Title IX rule requires colleges, universities, and other post-secondary schools to hold a live hearing in which both parties' advisors must be given the opportunity to ask the other party and witnesses directly, orally, and in real time any relevant questions and follow-up questions, including those challenging credibility. This right of cross-examination is also limited in some respects. Questions and evidence about the complainant's sexual predisposition or prior sexual behavior must be excluded as not relevant, except under certain well-defined circumstances. And questioning must be conducted only by the party's advisor of choice, never by the party personally. Moreover, either party may ask for the questioning to take place in separate rooms, so long as the parties and decision maker, with appropriate technology, can simultaneously see and hear the party or witness answering questions. And, ultimately, both parties have the right not to submit to questioning or even to attend the live hearing, and refusing to do so may not be used by the decision maker to make an inference, positive or negative, about the witness's testimony or credibility. For elementary, secondary, and other non-post-secondary schools, the final rules allow more flexibility to decide whether to hold a hearing. But even absent a full hearing, a school must give each party an equal opportunity to submit written questions for the other parties and witnesses to answer before the decision maker reaches a determination regarding responsibility. A decision maker must allow relevant questions to be exchanged, although, just as in the post-secondary context, questions about sexual history are generally prohibited.
The Title IX rule mandates that, after the filing of a formal complaint, the school provide written notice to the parties who are known of whether the standard of evidence to be used to determine responsibility is the preponderance of the evidence standard or the clear and convincing evidence standard. And the school must apply the same standard of evidence for formal complaints against students as for formal complaints against employees, including faculty, and apply the same standard of evidence to all formal complaints of sexual harassment. The Title IX rule also secures several rights for both parties after the conclusion of a hearing or other grievance proceeding, but before the decision-making process has concluded. For instance, the person deciding a sexual harassment case must not be the same person who received the formal complaint or investigated it, including the Title IX coordinator. The Title IX rule also requires the decision maker to provide the parties simultaneously a written determination of responsibility, explaining how the process played out, as well as the specific analysis underlying the conclusion for each allegation that is adjudicated as part of the final determination. This written determination must include whether remedies were offered to the complainant and the disciplinary sanctions, if any, imposed on the respondent. And the Title IX rules require that schools offer an appeal to both parties on at least 3 bases: that there were procedural deficiencies, newly discovered evidence, or bias or conflict of interest that affected the outcome. Other grounds for appeal may also be offered by a school so long as they are provided on an equal basis. The decision maker in an appeal cannot be the same decision maker who made the initial determination of responsibility. As we've seen, the Title IX rule provides both complainants and respondents significant new protections not only during the process, but also at its end. Sometimes, students or others may want to resolve a complaint before a formal finding of responsibility. And in those cases, the Title IX rule makes clear that schools can offer and facilitate informal resolutions, but only with the voluntary written consent of both parties, and never in cases involving allegations of an employee harassing a student. This short video has touched briefly on many topics. To learn more about them and the entirety of the department's new regulations, please visit www.ed.gov/OCR. If you have questions regarding the department's new regulations, please send them via email to t9questions@ed.gov. Anyone who believes that a recipient has violated a federal civil rights law enforced by OCR can file a complaint online at ocrcas.ed.gov. Links to these sites and other information are posted in the video description below.